we need to talk about Trooper Proctor. There's more. And I would say I didn't expect this, but I kind of did. I'm just surprised we're seeing it. Like, I'm surprised we know about it. It's Tuesday. It's October 28th. We have a lot to talk about, law nerds. Y'all have followed along long enough to know that Trooper Proctor was put on administrative leave. Then they went through the entire trial board, through the law enforcement civil service process to decide what discipline, if any, would befall Trooper Proctor. And then he was terminated. And then he appealed it to the appeals board. And then they did the first days of hearing at the appeal board and said, essentially, this is why he was fired, and this is how it was decided that he was fired. And then they put it over more than a month. Well, no, it was like 3 months to have the defense present their case, and they had set aside 3 days. And then he stunningly withdrew his appeal. Just gone. And then his attorney withdrew from the other cases. And we were talking about which came first, chicken or the egg, a little bit. And we didn't have a ton of information on that. Did he withdraw his appeal because of the discovery of his iCloud that it seems that he thought was gone, wasn't gone? And we suspected the timing was like, yes, that discovery, maybe he and his lawyer had a heart-to-heart and were like, there's nowhere we can go with this. That's not exactly what happened, and now we know. The Boston Globe has a statement from state police letting us know that it didn't go down quite the way that we suspected it did. Similar, but don't we love the more details? State Police Union pulled support for former Trooper Michael Proctor prior to appeal drop. Whoop, there it is. The union for the state police troopers pulled its support for former Trooper Michael Proctor's appeal of his firing shortly before he dropped it last week. Quote, following the discovery of new evidence from Michael Proctor's cell phone, the State Police Association of Massachusetts Executive Board unanimously voted to sever all support from his appeal. Brian Williams, the union president, said in a statement, "We hope this decisive move closes a deeply embarrassing chapter in state police history." I don't think I've ever seen A, a union do this, and B, make a statement that they did it. They're like, we might not drive the bus, but we're riding shotgun. And we're throwing you immediately under it. So once the union noped out, the union lawyer noped out, and that had to have been on like Friday when he signed that he was also withdrawing his appeal. Because when you don't have the union support, there's no way his appeal is going to go anywhere. Friday, there were new filings in the connected cases. We looked at filings from the Walsh case. The filing that we're pulling up now is from the Myles King case. We have not gone over those cases other than the discovery fights. The Myles King case is the case where Lally was on the stand talking about, well, I asked for the discovery and Proctor didn't give it to me. And the defense is like, and then? He's like, well, and then nothing. Okay, that case. Commonwealth versus Myles King, the Commonwealth's motion for protective order regarding information derived from review of extraction of a former, they don't even name him, of a former Massachusetts State Police trooper's personal phone. We all know who you're talking about. The Commonwealth moves pursuant to Massachusetts Rule of Criminal Procedure 14.2G. Remember, Rule 14 is the discovery section. That dissemination of materials from an extraction of former State Police Trooper Michael Proctor's personal cell phone be restricted. On June 17th, 2025, this court, in specific cases, footnote 1, it lists all the associated cases, including King and Sinchero, De Los Santos, and others. In specific cases, allowed in part defense motions for discovery of former Trooper Proctor's personal cell phone. That order included that the Commonwealth produce communications from the dates of the charged offenses to the dates that indictments issued, and produce any other data from Proctor's personal cell that constitutes investigative materials or is favorable to the defense within the meaning of Rule 14. The Myles King case goes back like 5 years, mostly because of like Mass State Police and prosecutor delay. But it opens up a treasure trove of phone because of how old the case is. The court further ordered that the Commonwealth may move for appropriate protective orders for the court's review prior to producing the items or information, and that, quote, defense counsel shall not show or provide the communications produced pursuant to this order to anyone else. If these things leak into the media, the court's going to be fucking pissed. To anyone else except that defense counsel may show but not give them to the defendants in this case. So they may talk to their clients about it, they may show their clients, but they cannot give their clients digital copies, physical copies, anything like that. Upon filing of a motion and amended motion for clarification by former Trooper Proctor's counsel on August 13th, the court clarified that, quote, the obligation to produce any other data that constitutes investigative materials or is favorable to the defense is not limited to a particular date range. So the court said you need to turn over materials from the date of the crime through the indictment plus any of this. The plus any of this is not limited. Former Trooper had a legitimate interest in protecting attorney-client or spousal communications. Remember, that's going to exclude things like group texts. And we know he's fond of a group text. We've seen those texts from the feds. The motion goes on to say the court issued further orders about discovery and extraction of the phone, the opportunity for the former Trooper's counsel to submit a privilege log, and a timeline for the Commonwealth to produce discoverable materials. Trooper Proctor's lawyer is, at the time, because he's now withdrawn, but was able to go to the prosecution and said, this phone number is wife, this phone number is lawyer, so these communications between this number and this number should be privileged and should be excluded. And then said that the Commonwealth had a certain amount of time to turn these things over. That's footnote 2. Footnote 2 lists the cases again. Review of the personal cell phone is ongoing. At this time, pursuant to Rule 14, the Commonwealth is producing text chats, audio files, and video files, which span many years. One text chat contains highly sensitive information, including images of intimate body parts of people not participating in the chat, screenshots of Facebook posts by non-participants, images of non-participants, full phone numbers and personal email addresses of the text chain participants, and the name of a sexual assault victim. They are not his images. They are someone's body parts. We do not know who. We also do not know if he is the one sending those photos or if someone else in the chat is sending those photos. We do not know that. The prosecutor in the motion for protective order goes on to say non-parties have a privacy interest in not having their images, their complete cell phone numbers or email numbers publicly displayed. Names of sexual assault victims in court records or police reports may not be disseminated except with the consent of a justice of such court where the complaint or indictment is or would be prosecuted and are otherwise withheld from public inspection, except apparently in Trooper Proctor's group text. Further, non-participants who appear within the produced materials may have a security interest in not having their personal identifying information released to protect against harassment. The materials will be provided in an electronic format with text chains, including embedded audio files. The voice chats, where the text chains include the name of a sexual assault victim, the Commonwealth requests that it be allowed to omit the electronic version of the messages that include the victim's name from the electronic production so as to redact the victim's name and provide a PDF. So this was filed in the Myles King case. There are numerous other cases where there are fights over these downloads. A number of you asked, and it is a great question, a number of you asked, does this negate or moot the fight that is ongoing over the federal discovery? I don't think that it does. Here's why. The federal discovery is extractions maybe from Proctor's phone, maybe from his work phone, maybe from both. We don't quite know. But if I was the defense, I would want to take a look at what is in the downloads from Proctor's discovery from the feds and anything that might have changed in the discovery turned over by the state. So I think the defense needs to still fight for both. We are now looking at the Commonwealth requesting a protective order regarding Trooper Proctor's personal phone. Remember, there are two sets of data that we are talking about sometimes simultaneously. There is the federal discovery that was turned over in the Reed case. That is the federal set. And then there is the state set. The state set of discovery is the recently downloaded, discovered Proctor personal phone, well, iCloud, that goes back to like 2013, which seems like it's not that long after maybe iCloud started. But the Proctor personal phone from the Commonwealth goes back to 2013 with hundreds of thousands of everything. The federal discovery is what we saw being discussed last week in a hearing. The federal discovery was part of the grand jury investigation that we heard about in the Reed trial. The federal discovery was part of their investigation, and it was turned over to Karen Reed's defense attorneys and to the Commonwealth prosecutors under a federal protective order that could only be used for that case. There has been much fighting going on over what will be turned over in these other cases because there is a federal protective order. And we talked about the situation where the Commonwealth had information they believed was discoverable and then said, but we're under a federal protective order not to give it to you. And then we got all the way back around to, we asked for the things that we think are discoverable. We've received permission from the feds to turn over what we think is discoverable. And the defense saying, how do we know there's not more? And the prosecution said, well, we'll give you the log from the federal grand jury and you can make those arguments. We'll see more of that on Thursday this week on the 30th. But there are two sets of information. The federal set of information, when the feds turned over the discovery to the state, they said, hey, you can only have this for a limited period of time before you have to give it back to the feds or destroy it. So that's why there is discussion of the kind of give back or destroy, not seek and destroy, give back or destroy. But it doesn't mean the feds are getting rid of it. That means the state prosecutors have to hot potato it before that date. But the feds aren't getting rid of it. The feds said, you can't just keep this forever. There is still back and forth going on over the federal set of discovery, different than the state set of discovery. Ultimately, the defense attorneys are going to have to get the information that they're entitled to. And what I think the judge is trying to avoid is a situation where the defense attorneys are saying, we know there's discovery. You won't give it to us. You have to dismiss this case. These cases should be tried on their merits, but the defense has to have the discovery to do it. And sometimes when there are discovery violations, the ultimate consequence is, well, then you can't put this case to a jury. And that is the consequence I don't think the court wants to see. But the defense getting answers to the two-way request isn't going to go well because it's federal grand jury materials. They're all sealed. They aren't parties to the case. And the feds have already indicated in other motions that they're disinclined to help at all. So it puts everyone in the state case in a difficult spot. And that's why there's another hearing about it this week. What do we do about the federal discovery? In addition to the treasure trove of Commonwealth level discovery. But if there's different things in the federal discovery than in the state level discovery, the defense attorneys have a right to know what was yeeted. If the defense attorneys in this case don't have Proctor's work phone and the federal discovery has Proctor's work phone, they have a right to that too. My empathy is fairly limited for the state in this, but I get where a prosecutor is sitting there going, so there's a federal protective order and a discovery obligation. And we are stuck in the middle of those two things. And I think the court needs to just say, you can't destroy this until this issue is settled. If that means that the prosecutors for the Commonwealth are violating the federal protective order by not destroying it, then they're going to have to go fight it in federal court. Because you're talking at the end of the day about the defendant's constitutional rights. So if you don't destroy it by the date, what's going to actually happen? And I'm sure the prosecutors aren't thrilled about finding that out, but it's a real unusual circumstance to be in. I don't know if the feds know how to navigate it either. I don't think you can turn it over in violation of the federal protective order. But if the court orders you to not destroy it, then I think you have to not destroy it. And at this point, I'm very much pro turn it all over and sort it out. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the LawNerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.